Okay, hello everyone, and we are back Thursday, January 29th, 8 o'clock, and we always start on time with our 42action.org law calls, super informative, riveting at times. We always have an incredible guest. So excited tonight. We are flipping it over to Brad. And
I'm here. Oh, was that my handoff?
I was talking at the same time. So excited, Brad. Who do you have tonight on our call?
Okay, well, good. Okay. Hey, everybody. Like Randy said, welcome to the 42 Action Call. We've got with us Donna Steenkamp of Title Tracks. Donna, welcome to the call tonight.
Thank you very much for having me.
Yeah, a little background, everybody, on how I came to be speaking with Donna. I'm a regular listener to a podcast out there, and I'm a big podcast person. It's kind of become one of my new favorite choices. But I was listening to a podcast called It's Rainmaking Time, hosted by Kim Greenhouse, and she has a variety of subjects on there. And I heard her talking about this topic, and she introduced this woman named Donna Steenkamp, who proceeded to tell a story of how her property got taken away from her and how she did not take it lying down. She fought back, and there's a whole story that goes with that. So with that in mind, again, we're welcoming tonight Donna Steenkamp, and I'm so thrilled, Donna, that you're here. Are you stateside now, or are you overseas?
No, I'm still overseas.
You are? You're coming? Are you still down there in South Africa?
Yes, I am. Thanks.
Wow. So everybody, we've got Donna joining us all the way from South Africa. Maybe I shouldn't ask what hour it is over there right now, but you're probably used to that, interfacing with the States a lot, I suppose, huh?
Yes, I do. And I travel back and forth a lot. I have family over here with some family matters going on, so yeah.
Well, Donna, let's jump right into it. Title Tracks is headquartered right here in Orlando, and it does a very specific thing. But why don't you give the background story that I heard you tell on Kim Greenhouse's show?
Oh, okay. We bought a piece of property. It was our dream property in Colorado, my family, and we had the intention of building on this property, and it was the most pristine, beautiful, with the creek and the rock formations and, up in the mountains in Colorado. And about 3 months after we bought it, a drunk driver hit a wall that we had, a retaining wall, and we went down to the county and learned that the entire property was illegal. It was zoned commercial. All the buildings were in the county right-of-way, and everything that could possibly be wrong with the property, it turned out to be ours. Long story short, it turned out to be that our closing and all the documentation that was used in the closing was also illegal, including a appraisal that was $100,000 over what it was supposed to be. Just so much wrong. And we're going through all this litigation with this piece of property, and suddenly we find out that this bank, HSBC, all of a sudden steps into the picture and says that they own our loan and that they were foreclosing. And it's like, well, who the heck are you? We knew nothing about these people, and we were not late in our payments or anything like that. And because of the problems that we had legally with the property, our interest rate wound up going to 16.875%. And when we tried to refinance the property, we learned that we couldn't because it was zoned commercial, and a residential loan couldn't be put on it, and it went on from there. So a payment that was $1,400 a month went up to $3,600 a month, and then we all of a sudden have this strange bank coming in and telling us that they own this property and that we should be paying them. And I asked for proof, and they wouldn't provide it. So I dug a little deeper and couldn't figure out why in the world this bank was doing this. And learned that they had sued my lender in Georgia and closed them down, and they just didn't think that anybody would check. And they found, it turned out that they were trying to foreclose on the lender that they had shut down in court, and they just stepped in and took over all the property. No assignments, no endorsements, nothing, not even a sticky note with these guys' name on it. And it got to be a very, very, very nasty fight with them. And
Donna, what year was this? What year was this?
This was 2008 by that time. We bought the property in 2003.
Okay.
And we had gone through, we were going round and round with suing the title company. We wound up suing everybody. We sued everybody because of this problem. Because it was just, it wasn't covered. The title company wouldn't cover it. The realtors and brokers says, well, we're not responsible for that. We didn't know. And it's like, which means they didn't do their due diligence. Nobody claimed anything for anything. And we were stuck with a piece of property with a note that was ungodly, and we couldn't do anything with the property. We couldn't do anything. We couldn't build. We couldn't do anything. Nothing.
You were trapped, and like you said, you had not missed the first payment. Everything was current, and they're still trying to foreclose on you.
Well, yeah. What happened is we were overpaying because we would overpay. We bought this little property, and my husband had a very good income. And we paid $230,000 for this piece of property, and we were more concerned with the property than the house that sat on it. So we were planning on, gutting the house, living in it while we were building our dream house across the creek, and life was supposed to be wonderful. Right. And it never turned out that way. And when we started dealing with planning and zoning, after the drunk driver hit the wall and we found out that the property was completely illegal and we could do nothing with it, nothing. We couldn't do nothing. We couldn't do anything. And they said it turned out that our case was one of the worst ones that they had ever seen. And the courts blew us off. I filed a quiet title action. I went to 15 different law firms to try to find someone that could help us. Nobody would help us. Nobody understood enough about what was going on. These were lawyers, and I anticipated them to know what they were doing with real estate law. They had no clue what was going on, not one bit. And then I realized that
this was in 2008. This was the day, now foreclosure defense has kind of matured, and there's a lot of case law out there. At the time, there was virtually none of that. You were going it virtually in the dark on your own, weren't you?
Absolutely. And the scary part was the more I got into it and the more digging that I did, more questions. It just kept mushrooming. More and more questions kept coming up. How could this be? Why was that? That kind of thing. And then after dealing with talking with attorneys, I realized they just didn't get it. And then it dawned on me that you need to know real estate law, you need to know title law, you need to know consumer law, but there's also the securities law aspect of it. And that's the part that nobody had. So they were not seeing the whole picture of how all of this fit together. And that was vital. That was at that time, that was very important because nobody understood about the securitization of loans and the loans being sold and put into REMIC trusts and and all that kind of stuff. Nobody understood.
So that was the case. So that was the case with your loan. You eventually found out that it had been securitized and sold off.
Oh yeah, absolutely. And then I learned all about the MERS thing, and MERS was the nightmare in everybody's world. It was a terrible, terrible thing that they had come up with the banks, but it was basically used to defraud everybody.
Right.
And you'd be real surprised, I'll guarantee you, if everybody looks at their mortgage, if you did anything with a mortgage since 1999, you will see a MIN number, M-I-N number. It's I think it's 16 digits. If your note has that, your note's been securitized. You have no idea who owns your loan. You have no idea.
Well, all this, I mean, for somebody that was looking to build a dream home, this is a shock.
I know.
Yeah, I
know.
Randy, can you cut off those talkers? Yeah, okay. Donna, can you hear me okay?
Sure.
Okay. Yeah, so, I mean, all this was eye-opening. How long was the process for you to kind of get this education by the seat of your pants? How long did this all take for you to get up to speed?
At that time, I wasn't even anywhere near as I am today. But it took me a couple of years actually because we were in litigation. I did have an attorney that would take it on the rezoning side, and then we had to sue the title companies, and we had to sue the banker. I mean, the brokers. We sued Coldwell Banker. We sued all of the people that were involved in that. The appraiser, and that little part of it, they understood. They continued on with that, but then I still had this business with HSBC going on, and nobody understood that part.
Right.
See, that dealt with the documents. That dealt with the documents on their face value. So what was being filed in county records wasn't really what was going on.
And that's the key part of your story where you're going, because I know eventually you'll get to it, but what's in the county records is not the whole picture by any means, is it?
Oh, not even remotely. Not even remotely. And it turned out to be, and the big kicker for me was when I really knew I had to start digging in and finding out what the heck was going on, was when I learned our property was listed as residential in the county records. However, in reality, in planning and zoning, it was commercial. The reason why it was listed as residential was because it was being taxed that way. Not because the actual zoning was that way. And that was enlightening to me. So, long story short, I mean, this is a whole big process as it was going. I couldn't find an attorney or a law firm after going to 15 different ones that would understand as much as I did. So I figured, well, you know what? It's like I'm standing in front of a train that's coming at me. I have to do something. I'm not going to just lay over and let them take my property illegally. So I filed my suit.
Yeah, is that your quiet title you're talking about?
No, at the time I filed a quiet title to try to stop them, saying that there was an adversarial lender that was claiming ownership. I figured that was, if I filed a quiet title, that would compel the court to make them prove how they got my loan, because nobody was listening. I went to the Rule 120 hearing after they filed the foreclosure documents. I went to the Rule 120 hearing, which is for a foreclosure. And Colorado is a non-judicial state, so that's how you do it. When I went to the Rule 120 hearing, the judge point blank asked me, are you late on your loan? And I said, no, Your Honor, you're not. I'm not, and I can prove it. And he turned to the attorneys, HSBC's attorneys, and said, is this, are they late on their loan? And they said, well, they're not paying us. So yes, they are, Your Honor. We haven't gotten any funding from them. And they said, do you own her loan? And they said, yes, we do, Your Honor. I piped up and I said, Your Honor, I please compel them to show you that they do, because they will not show me. Under statute in Colorado, they are required, if I ask, they have to show me.
Right.
By law. And the judge turned to these two people and said, do you own her loan? And they said, yes, Your Honor. He says, do you have paperwork? And they say, yes, Your Honor, just not with us today in court. And it was like, you've got to be kidding me.
Yeah.
And this judge turned to me and said, lady, if you don't pay your mortgage, you're a deadbeat, in front of the courtroom, and called me a deadbeat.
Right.
And ordered the sale of my property. Well, that was it for me. That was it for me. I've dug in deep.
Yeah.
So,
well, what was going through your head at this point?
I just couldn't believe it. I could not believe that the judge would do this. I begged him. I said, please, I can prove, please just grant me a hearing. Let me prove it. I can prove it. And they wouldn't. The judge would not do that. So
that's one tragedy. And then later on down the line, you decided to kind of, like you said, dig in your heels, and you went ahead and did a quiet title then, correct?
Yes, I immediately went down I went straight from that courtroom down, and I filed a quiet title action. I had it ready, thinking, I was going to see. I had no idea that the court was going to tell me that. I had no idea that they were going to do that. So they had ordered the sale, but it hadn't gone through yet. So I figured I'm going to jump in there and get my quiet title going, so that I can put notice on the record that there is litigation. I'm putting notice to anybody that's out there that I'm questioning this foreclosure, and that I thought that by doing a quiet title, I wasn't getting anywhere with this Rule 120 hearing. I was going to see if I can bring it into a different judge, and he would help me get my hearing, and I can prove it, and then life would be fine. Well, that never happened either.
Well,
and
you kind of, on your quiet title, I remember your story, you thought things were going your way on the quiet title for a little while, right?
Well, what happened was, the interesting part about that, I did file the quiet title, and I had the whole complaint together, and I had all the proof that I was supposed to have presented to the court then. So I put it in my complaint. So the court now, in the quiet title, was aware of why I questioned, HSBC having anything to do with it. At the same time, I also filed I figured no guts, no glory. They're going to take my property anyway. I might as well. I went and I filed a lawsuit in federal court. So at the same time, I've got a lawsuit going in federal court for mortgage fraud. And then I have another one going in district court, which is where the property was, on a quiet title. So we're going through this whole big mess, and it's very daunting to go and representing yourself in a federal court. There's a lot of attorneys that have never stepped foot in a federal court, and everybody thought I was absolutely crazy. And so I figured, no guts, no glory. They're going to take it anyway. What do I have to lose? Right. So HSBC got really, really nasty, and the judge was reprimanding them and saying, telling them that they needed to, get back in order, and that their aggressiveness was getting out of hand, and they were getting really nasty. They told us they were going to ruin us. They told us we were going to pay for the rest of our lives, and they were going to come after us. They threatened us. Well, at the same time, I got this quiet title.
They said this.
Oh yeah, the judge reprimanded him right there in court.
Wow.
Right there in court. So the judge was kind of favoring me at this point. And so at the same time, I had this quiet title thing going. Well, I did the whole quiet title thing. I presented it to the court. I waited the time period that you're supposed to. I think it was like 20 days, but I had to wait 30 because they were out of state. So I waited the 30 days, no response. I was on it the minute that, the 30-day mark came up that nobody responded, I immediately filed motion for summary judgment, or actually motion for default judgment, because there was nobody answering, nobody responded.
Right.
So I thinking, oh my gosh, I just got my property. So I got I got the court order saying motion for default judgment granted, stamped by the court. And I'm thinking, oh, my God, this is fantastic. Well, that very day that I got the stamp thing from the court, HSBC was threatening us terribly. They were horrible. But at that point, I figured, well, I already got my property. I don't care, So I went back into district court thinking, okay, well, I'm going to settle with these people and just get them out of my life. I got my property. I've got them out of my life. 4 hours after I got the stamped approval from the court on my quiet title, 4 hours later, it was vacated. In the meantime, I had settled my federal case.
Oh.
So I settled the federal case thinking I had my property because I had this order from the district court saying I have my property. I went back into the federal court and I said, Your Honor, I'm way above I just played, blonde. And I said, Your Honor, this is way too daunting for me. I can't do this. Please don't, I don't want anybody coming after me or anything. I don't want any more repercussions. I settled. And I said, don't come after me, and end of story. And I closed it. Immediately after I closed it, they vacated it. They vacated the thing in district court. So somebody was paying somebody. Because the timing was just way too perfect. Way too perfect.
So you win a case in the local, then you march over there and you settle the federal case just because you won your district case, and then lo and behold, 4 hours later it's vacated. That's too much of a coincidence, obviously.
Well, oh yeah, and they would not even allow me to have a hearing. They would not allow me to have a hearing at all. And HSBC's lawyers lied to the judge, flat out lied. Now, here we are, 2014, last year, that attorney, that law firm, was reprimanded and that law firm is closed down in Colorado as a foreclosure mill.
Wow. Yeah.
So everything I had said, I had filed everything with the state of Colorado. I filed complaints against the judge. I complained because I wouldn't get my due process rights. I complained to everybody, and everybody blew me off. Everybody. They all blew me off. They all didn't see any problems. None of the Department of Regulation didn't see that the realtors did anything wrong by selling me a property that was actually zoned commercial. They didn't see anything. Nobody saw any problems with anything anywhere.
So nobody saw any problems, and your house was taken from you, was foreclosed on a house where you were current on your payments, and you had the proof. That's the mind-blowing part here.
Well, yeah. Well, even if I wasn't current on them, they didn't have the right to do it in the first place. But I had an accounting. I had an accounting. It took me, a year to get a full accounting from HSBC. When I looked at the full accounting of what we paid from the day we bought the property, I dove into it. I mean, I dove into every single payment, and I matched all their payments that they had from the records that they took from South Star Funding.
Right.
I matched that against the payments that we had, and they didn't match. They didn't match. So even if it didn't matter what I did, no matter what, the whole thing, none of it was right. None of it anywhere. And then I started. I'm sorry.
I'm sorry. Go ahead. Finish your thought.
No, and then we started seeing. I had the property when this was all going down there right before I filed a quiet title. And HSBC was making all those rumblings and everything, and we knew that we were having problems. We had just gotten the other little lawsuit that was going on with, we had to sue the title company and the brokers and all that kind of stuff. That was a third suit that was going off on the side that I didn't have to do myself. That the attorneys were doing for whatever. I'm not going to go down that path. Anyway, they wound up settling and saying that they were going to try to rezone the property, and they wound up having to pay out a little bit. I think that they paid to cover the property to be rezoned partially, not all of it, just the one little part where the house was. The rest of the property was still back. So anyway, with all that going on, there was just everything was happening all at once. And nothing was gelling anywhere. So I put the property up for sale. I had two contracts. I had two written contracts on that property. We paid $230 for the property. I had two written contracts for $270 on that property. When we went to HSBC, because they're telling me that they're the lien holder, and they're claiming this. Well, whatever. So the realtor that we were dealing with said, well, we're just going to see what they come up with, and they said we kept asking for a payoff to find out what it was, and we got 4 different payoffs over 6 weeks. It took us to get those 4 payoffs, and they were all drastically different. The first people that wanted the property, the first contract that we had, because of all those shenanigans that HSBC was doing and couldn't come up with documents, and they couldn't come up with payoffs, and they couldn't come up with all this stuff that the realtor needed, they were just blowing off the realtor. The people bolted. They said, "I'm not getting involved in this. Something's weird here."
Right.
So then we had that second contract. And these people were all excited. Well, the same thing happened with them as well. Then we found out that HSBC finally did come back with the first payoff, and it was $53,000 more in fines.
Wow.
That they tacked on to the property. Now, this isn't the heyday when all the foreclosure stuff was going on and everybody was, all this, and they were trying to get everybody to not be in foreclosure, and they were trying to settle with everybody.
Right.
Well,
right.
HSBC couldn't do anything. They were pulling numbers out of the air, because they came back with 3 different numbers over a period of 2 weeks. So nobody knew really what they were doing. They couldn't produce any documents of any kind. They couldn't produce anything to allow this sale to go through, and then they tacked on this unbelievable amount in fees so that the sale couldn't go through in the first place.
Yeah, fees for what? If they couldn't produce anything, what they had fees to charge? That's
exactly. Well, they were putting stuff called a broker price option. There must have been 42,000 of those at $300 a piece. But then when you also looked at the actual internal accounting of the property, of that what HSBC had provided me, the money was flying everywhere. It was going into suspense fund, it was going into escrow, it was going out of here, and then it was jumping around from day to day. The amounts were jumping around. None of it made sense. Nothing. And that was the internal documents from HSBC that they just made up.
Well, they cost you the two buyers. After the second buyer went away, it was probably starting to dawn on you that, yeah, well, and there goes your property. You're done. You're out, right?
That's right. That's right. And I was running out of things to do. I went to the media. I went to the Attorney General. I went to the governor. I said, something is wrong here, please. Something is wrong here. And they all thought I was absolutely a lunatic, crazy woman that didn't pay her mortgage and that all kinds of, that I was just some chicken little person saying that the world's coming to an end because all of this stuff is happening. Nobody believed a word I said.
Yeah, I love the fact that you had the gumption to go to the Attorney General and the governor and the media. No, I mean, no. Who does that? You did it, obviously, and it still didn't go your way. But when did your thinking start to turn around, and you were going to start to kind of? I mean, because at that point, I personally probably would have been feeling pretty low and feeling pretty bad. When did you begin to turn that around and kind of let the phoenix start to rise from the ashes, and you end up with what's going on now?
Well, it was kind of a strange thing because the stress and the trauma that it caused my family, because I had two small children, and the stress and stuff was just unbearable for my family. My oldest daughter is still, that was 2008. My oldest daughter now still is having post-traumatic stress syndrome and is being treated to this day because of what happened. My husband couldn't deal with it. He got so angry. We had to get out of Colorado. That was it. We had to get out of there because he just could not believe that this had happened, that this was allowed to happen.
Right.
Me, I couldn't let that anger get it to me. I had to do something. And my personality was, okay, I got to figure this out. I got to figure out how this can never happen to anybody else because this is the most horrendous thing ever. And with what I knew and what I had learned about fraudulent documents and about, the law, and I mean, I started studying law. I started studying real estate contract. I started studying everything. The securities law, that was the big one. That was the big big element that nobody had, all the attorneys that I had dealt with. And I started following every single case, every single brief, everything across the country. I was consumed. To this day, I'm still consumed with this whole thing. And I figured, well, the only way that this could possibly be fixed, because not only you've got two problems going on here. You've got 400 years of successful county records being corrupted. That because of this, it started in 1999 when the banks started getting really greedy, and that's what the MERS thing started. And it actually started in 98, but it actually kicked in 99 when they changed. They were playing with the name and some legal stuff with that. But when this whole thing, I realized that this was not something that one industry could fix. It's not something that the title industry could fix. It's not something that the lenders would fix. They were the ones who were causing the problems, and they could not possibly admit any liability to anything because it would open up an onslaught of litigation for them. Then all of a sudden you started having the national mortgage settlement thing that came down, which was the biggest joke ever in the history of America. it was a $25 billion settlement with all the 50 AGs thinking that they all got this great thing and they're all, settling this whole big thing for these poor homeowners. Well, you know what I got out of that? I got a check for $500 for the privilege of handing my property over to HSBC. $500 I got. The state got rich. The attorneys got rich. I got nothing. So, I mean, it was just horrible. So the only way to fix these problems, not only were the titles bad because of what was happening, because you've got all this fraudulent documentation, and the minute what was happening is when the economy went south, the lenders, after they were securitizing all these loans, they destroyed all the original documents. Now, for whatever reason, there's all kinds of versions of why they did it. That because it was turned into a security and it can't exist at the same time as a negotiable instrument, it was double dipping where they were selling the property to the homeowners and getting the money from that, and they were also selling the same property, same title on Wall Street to God knows how many investors that they just put this property supposedly into this trust or whatever, this security to sell investors. They've tracked these things up to 40 times that these loans have been sold behind the scenes, and you never knew it as a homeowner. You never knew any of that was going on. I tracked mine. I was able to track mine from what limited resources that I had, that HSBC, who didn't have one single red cent into my loan because they never put anything in there. They didn't finance my house. I tracked down that they were compensated 5 times in my my loan alone, 5 times for something that they had not one red cent investment in.
Incredible. And so it's easy to see, they slipped a few bucks here or there. There's no proof of that, obviously, but they could buy off. I mean, for them to do bad things just to win is nothing to them. And there's probably some of that's been going on, although we'll probably never prove it. You said something very interesting on the Kim Greenhouse call. You said these title companies, all that they can rely on is what's in the official records, what's in the land records, and if they find something they don't like, they'll just insure around it. But they're relying on records that are totally inaccurate, so their insurance can only be as accurate as what the county records are, and even that's not very accurate.
See, that's where the kicker comes in right there. What had happened when the economy went south and the lenders were starting to foreclose on people and there was a lot of default on these loans, all of a sudden, in order to be able to foreclose, they had to have original documents. Well, they destroyed the original documents, or they lost them, quote unquote. They lost my note. Nobody could produce my note. So, what they did, there was a company called Lender Processing Services, LPS, and their CEO or president, I think she was, is sitting in jail right now. She's in jail after telling the Senate committee or a congressional committee or whoever that her company literally was hired by the banks to refabricate every one of those missing documents. So they would present this fabricated loan that was they had some copy somewhere and they just made them up, and it wasn't the ones that the homeowner signed, and they just started filing these things into county records starting in 1999, and they just started reproducing all of these documents, and that's what happened. That's how the documents started getting in there. Then they started doing the real kicker was the assignments. They were foreclosing in the name of MERS, and then there was a whole big ruckus about MERS not having any authority to be able to do that because basically MERS was a library and they had no skin in the game. So how could they file that they had a loss? Then MERS came back and said, well, we're changing our bylaws and don't ever foreclose in the name of MERS. But at that time, millions of foreclosures have gone through in the name of MERS.
Right.
So so all of that they were backpedaling. They spent the entire time backpedaling, recreating documents, refiling them into county records, redoing assignments, and then all of a sudden, the accuracy of county land records was completely compromised. There are independent audits now that have been done, and they're posted on the bottom of our website. Some of the independent audits that have been done that have all stated what they did is they took one lender, they only looked at assignments, and they only did it for 1 year.
Well,
and that's the only small thing that they investigated. And what they did and what they found was that 75 to 80% of the documents that they looked at were bad or fraudulent in some way. 75%.
That's an amazing figure. Yeah, almost 4 out of 5 are bad, but that kind of segues us, Donna, into what you did. And Tyler, you just mentioned our website. Why don't you tell the listeners what your website is and the birth of your company and your website because of what you just said?
Okay. The name of my company is called Independent Title Review, and we come up with a product. It's actually a 3-step product, a solution. And it's the only legal solution that could possibly be done because the only way to clear a title is through a court action. It has to have a court order by the judge saying, that these are the reasons why we believe that there's something wrong with our title. We need a judge to review this, and he's going to agree, and we get a court order. That is the only way that you can clear a title. Now, you've got the title industry is out there insuring around all this stuff, but the problem is the title industry is not looking at the documents. They're taking the documents, what's in county record, at face value. They're not looking at the fact that those documents are fraudulent. They don't do that. That's not what the title industry does.
So they do not go past so they're making the assumption, here's a document in the official records. It must be accurate, so therefore I'll base my policy on that. But
that's right.
So they're not digging deeper beneath the surface.
No, not at all. That's not what they do. A title company does liens and encumbrances against the title. They don't go into the financial documentation. They'll look at it on the face value, but they don't go in there to question it to see if there's really, that there's really been robo-signed or that it's really, We have cases that we've done title tracts reports for where we had a reconveyance from a company in Montana. This was for one of our clients in California. We had a conveyance from a company that didn't exist. It stopped doing business in 1962, but in 2010, they signed a reconveyance. And then a month later, the exact same person that signed that reconveyance, the exact same person, same signature, everything, as a vice president of Wells Fargo, signed a satisfaction of mortgage.
Wow.
How the heck can that happen? That's impossible. So what we've done is we've developed a 3-step solution. The first thing is we run what we call a title tracts report, and we get into from starting at our client, which is the current owner usually, or the kind of current holder, and we start looking at the documents involved in their transaction, and then we mushroom out from there. And we look into stuff like fraudulent documents, assignments, that kind of thing. We look into fraudulent notary stamps. We look into the actual, and this has been a big one. This has been huge. In fact, in the last couple of weeks, a lot of our clients that we've had, it's amazing. The corporate status of the company that either wrote the loan in the first time or who foreclosed. We checked both of that. If there was a foreclosure anywhere in that chain of title, we would check to find out if that company had standing in that state to be able to do that.
Wow.
We have a guy that we have a client that was in the middle of a bankruptcy, because this applies to everything. It could be a bankruptcy or a foreclosure. It could be our focus was just on homeowners that really don't own their property that think they do. That was what the whole process was for me, because I didn't want people to have the same thing happen to them that happened to me. So when we did this, we started having and investigating all of these things. It started mushrooming them out and started applying to all kinds of different litigation and different reasons why people needed to look into their title. You need to do it. It's too big of an investment not to pay every month and not own.
So, I mean, it sounds like title tracks, what you're talking about, this independent title review, this is really what the title companies should have been doing, but you're doing it far more thorough, and you're providing the true and accurate, complete picture, a 360-degree picture from all the different angles, from the security, I don't know what security is. Yeah.
Not really. No, what I've developed here is basically something that complements, because the title industry you still need to do what the title industry does. You still need to check those titles for liens and encumbrances. What we do as of 1999, which it never used to be a problem before, 1999 when they started doing all these games with the loans. Before that, the title industry, they never had to look into this stuff. It never was something that was ever an issue. So they're not equipped to look into this kind of thing. So you still need what they do, and they still offer the insurance, the title insurance, and the title policy is effective as they are or aren't, and that's even debatable in my case. But you still need the title. The title industry basically needs us, basically.
You're complimentary and more comprehensive, it sounds like.
Yes, we investigate events that they do not, but that are now necessary that can also cause a cloud of title. We're not a title. We don't do title searches. Basically, what we do. When I was dealing with the attorneys, even to this day, I still have a problem trying to explain to an attorney what we do. Oh, the title policy will cover everything. Well, no, it won't. There's two things to that. The title industry is digging in, and they're not going to cover things that a lender did intentionally and the lender got rich off of. They're not going to cover them.
Right.
They're just not going to do it. The second thing is the title companies are still. They're not equipped to do this kind of stuff. It would take a complete change in the way the entire title industry works in order for them to be able to do this kind of stuff. That's why we complement what they do. We're more of a new kind of a thing. Now, when I deal with attorneys and they tell me, I've been doing title work for 25 years and I know what I'm doing and all this kind of stuff, and I say, okay, do this. Forget everything you know about real estate law. Forget everything you know about title law. If someone comes to you with a document that is signed by a robo-signer, that has the circumstances like I just mentioned earlier, where the company was, out of business since 1962. This lender in Montana was, but yet there's a conveyance in 2010 from them, or a satisfaction of mortgage from them, signed by a guy from Wells Fargo a month later. If someone comes to you and hands you that document, is that a legal binding document? And they say, of course not. It's not. It's fraud. I says, well, that's what it is. That's exactly what Title Tracks does. We investigate fraud is what we do. We're not into the title thing. It just happens to affect title to a property. And once a property's been clouded, it could be 3 owners before that you never even knew, people that you don't even have any idea even exist. If that title was clouded back then, that makes every single thing afterwards also clouded, because you never got a clear title. So people are sitting around with a title that's not marketable.
I know from talking to you before, your services aren't really positioned for foreclosure defense. You're kind of more on the front end when you're doing property acquisition. Is that fair to say?
Yes. A property acquisition or current property ownership. We restore accuracy to the land records. We unclear the title. Our 3-step process is, the first thing you do is you get a title tracks report. We go in and we look at the chain of title. We start doing all the things I just mentioned. Then we take what we find, and then we melt it down to 2 to 3 things of the most irrefutable, undisputable, it is what it is things that would warrant the grounds to do a quiet title action, meeting state requirements. So once we've done the title tracks report and we've established that a title has been clouded and these are the reasons why, Then we go back to the client and we say, okay, you've got two choices here. Actually, you've got three choices here. First choice is, do you want to fix it? Or do you want to wait and see? Problem with waiting and seeing if something will happen later on down the line is because now you're in a defense mode. You have to hire a lawyer to defend your title or whatever else happens. If you've got some lender from God knows 3 owners ago, if you've got a lender that's coming in there, because there are cases out there now where 2 different lenders are claiming that they own that property. But that's only because nobody really knows who owns that property.
Right.
And so you now as a homeowner sitting in that property, and all of a sudden you've got these lenders like that have come out of the blue, like happened to me with HSBC, and all of a sudden they're filing foreclosure. I now have to hire an attorney, and it now turns into a defensive mode. You're now paying for an attorney on an hourly basis, and it's expensive. Believe me. I paid $63,000 in legal fees alone just to get my house taken away anyway. That's what happened to me.
Incredible.
Well, so nobody got rich, but the lawyers got rich.
How about some more examples? I mean, have you had clients that have actually used the independent title review and have been able to do a quiet title, and what's been the results?
Well, it's interesting because right now it comes over a period of time. Right now we're in the situation where we're doing the title tracts reports and we're providing them. We are having a big pushback from the industry where there's, the attorneys are saying, the title company is going to cover this when it happens, and we haven't been able to find many attorneys that will actually say, I understand what's really going on here, and yes, this is what's happening. All of the stuff we're doing right now, we are a very new company. Right now, because we were getting such pushback from the legal industry, we decided, okay, well, I don't want to have to go through this whole thing and have to try to explain this to attorneys to try to get them to represent my clients. Well, my clients want the quiet title. They do not want any question whatsoever. They want it done. But they're also it's costing them a fortune having to do it from attorneys, because the attorneys will do it for you, but we don't think that this is worth it, Anyway, so we came up with a solution to that. That's now in development right now. That is, I'm working with the American Bar Association in helping us to do this in each state, and it's called it's a quiet title, do-it-yourself quiet title. A quiet title action is a very different kind of a lawsuit. It's more of an administrative lawsuit. They call it a friendly lawsuit. It's not a get up and, you've got the defense attorneys and you've got the plaintiff's attorneys and everybody's fighting in court like you see on television, and then it's a big adversarial thing. It's all done by a judge by filing paperwork. You file the initial complaint. The judge looks at it. You wait your time to find out if there's any responses. It goes through a very set way of doing it, but it's all done through paper. It's not a trial thing. There's no trials. There's no juries. There's none of that. And with a quiet title action, the judge will look at it based on the merits of the complaint, on what we found. So the title tracts provides you with the merits on why we're filing a quiet title action, why we believe that this title is clouded. That's what the title tracts report does. It files that part. Then the judge will rule on your case, and like I said, we narrow our focus down to things that the judge cannot possibly say, there's a question here, because when you get a title tracts report, it also includes all of the supporting documentation on how we came up with this information. It includes examples of robo-signing, 10 different versions of this person's name, plus deposition saying that this person is a robo-signer from wherever. We provide all of the research, all of the ammunition that the judge can possibly look at and say, there's just no way you can say that this is not what it is. So we've narrowed that down for the biggest amount of success in your quiet title action. And once the judge goes ahead and does that, what we've done is, because quiet title actions are pretty much similar in every state will have their own little things. They may be 20 days in one state and 23 days in another state, 30 days in another state as far as how the response time is. You have some other little things that the state itself has thrown in there as well. What we've done is we have developed a portal. It's in development right now. It's 3/4 of the way done. That takes all of the research from all of the states, all of the state statutes, and is very state specific. We are setting up attorneys in all the states to oversee everything, to make sure everything is in complete compliance with everything, and you can do your own quiet title action. Once you've got your title tracts report and it says your title is clouded for whatever reason, you have a decision to make as a homeowner or as the owner of that property. Either you fix it now or you fix it later. Fixing it now, taking a proactive response or stance to this thing, stops everything right away before it gets ungodly as far as legal fees. Because ours, like I said, $63,000 I paid in legal fees only to not win anyway. You don't want to go down that.
Donna, let's talk about fees, because I know you're right. It's far less expensive, and I was kind of shocked when you told me earlier what the cost for a title track report is on the low side. It was, from what I recall, it was incredibly affordable. So why don't you talk about the costs and your website and how somebody can engage with the company?
Okay, the cost of a title tracts report is $499. Now, you can go and have a forensic whole big blown report done, which is used for foreclosure defense. It's applicable there. But for what we do, we are just clearing titles. We don't need that. It's not necessary. So I've paid over $7,000 in forensic audits and investigations into the finances and all this. I paid over $7,000 in reports just to get nowhere. $499 is a very, 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 that's you can't find anything out there for $499 that does what we do. It just doesn't exist.
Right.
And people will tell you you need all these things. Well, you don't. Not for what we do. We don't need all that stuff. So we've narrowed it down to be very affordable. Once you've decided that, okay, I do want to go ahead and fix this problem, or what's been identified here, that means the next step in our 3-step process is going into quiet title action to clear the title. Now you have 2 options. We are in the process right now of setting up attorneys in each of the states to not only oversee pro se litigants, meaning self-represented, which will be using our portal, but they will also do it for you if you want, entirely. Now, there's a big difference in cost there.
Sure.
Quiet title actions going through our portal will be about $1,250 plus your court costs, and we have no control whatsoever over your court costs. The court says this is what you pay to file an action, and this is what you pay. But the portal, if you elect to do it through yourself, the portal will actually it will take you baby steps right through the entire process. It will have notifications. Okay, this is what you do. Did this happen? Yes or no? If it did, then you go there. It goes to the next part of the portal that addresses that issue. If it doesn't, you go to the next part of the portal that will address that issue. It has notifications. It has timeline. It has all the case law. It has every single aspect. It has process serving built into the site. It has paralegals if you want, anything else on ancillary that needs to be done and you're not sure how to do it. It has also how to file public notices. It will walk you through with tutorials every single aspect of how to do your own quiet title. And a quiet title can range anywhere from $2,500 to $10,000 if you do it through an attorney.
Right. See, that's incredible to me, Donna. You coalesced it all, brought it there, like you said, with with everything, even down to the service of process servers on there, and the paralegals and everything, and you've made it state specific, and it's all there in one portal. And now you're rolling this out. By the way, we've got just 5 minutes, and Randi needs to take the call because at the top of the hour she has something else scheduled. How would you kind of wrap this all up for our listeners tonight, Donna, so they can best walk away with the best understanding?
This whole thing that culminates in the third step in our whole three-step process is the fact it results in a title track certification. It's basically going to be a good housekeeping seal of approval or a Carfax kind of a thing on a land title. The bottom line is you need to find out, because if not, I can go on for hours on all the cases that are out there currently in court right now. Where there's a case in Florida where the guy has he challenged his foreclosing bank, and it turned out the bank wasn't licensed to do business in the state of Florida. Well, he not only got that property back, he also got every red cent that he paid to that lender because they were not legally allowed to accept his payments. I can go on for months on all this.
Was that a direct result of one of your reviews?
No, this just happened. This had been in litigation for quite some time.
Yeah, I'm aware of the case you're talking about. Right, yeah.
Yeah, it's setting precedent all over the place. But the tides are turning. This is now coming out. People are realizing that over half of the land records in the country are bad. This is coming out now. It has to come out. The entire real estate industry.
This is just amazing. Donna, I need to kind of turn it over to Randi here shortly. But
no problem.
Give out your website. Where do people go to get up to speed on this?
Okay, it's www.titletracks, TITLETRACS.com. Titletracks.com.
Now, is that an overview site, or is that actually they can engage and then go through the portal right there?
The portal is not up yet. This is basically a temporary front site that just tells you why, what's going on. It has a lot of the facts and figures. It has a lot of the case law that's out there. It's basically informing people why in the world this is needed. The portal will be launched. We are getting ready to do our first round of crowdfunding probably in the next month or two, and that's when everything will start really, really hitting. Like I said, we're working with the ABA on getting the back end of the portal built, and that's where we're at with that.
Beautiful. So there you have it, everybody. Title Tracks, TITLETRACS.com. You've been listening to Donna Steenkamp, and I hope you were as moved by her story as I was. Donna, thank you so much for calling all the way from South Africa to be with us tonight. And I hope you can come back next time, and hope we can have you back. And next time we'll open up for a little Q&A and let some of the listeners ask you some questions.
Yeah, when we launch the portal, and it'll be great.
Donna, you were amazing. Brad, awesome interview. Thanks so much, you guys. This was, I know that you're going to get some traffic, Donna, from that, and it just makes, a lot of people, even if they're in any kind of a home mortgage, the price is right on. So it's not one of these super high prices. So great job on that, and so glad that you got that education so you could share it with us. So you have an open door. Please come back as you get updates. Reach out to me or to Brad or both of us, and please keep us updated on what's going on.
Great. I appreciate your time, and thank you so much for listening.
Thank you.
I really appreciate it.
Okay, you guys, now the second half of our call tonight is on committees of safety, and if you looked at your email, there was a little bit of information that I put in there that this gentleman, Wolf, that is going to be doing this next half, put in there. And he basically said the answer is simple. If we want our constitutional republic back, he said that it's the agents of the government that make bad laws, which we know that, judges who violate your protected rights, and law agents who enforce them. So do you want to learn how to stop these corrupt agents? Okay, so here's what I'm going to try and do, and I don't know if it's going to work. So what I'm going to do is, if everybody's got a pen and paper, I'm going to read this off 2 times in case we are disconnected, and or you want to hang up and just dial in directly for this committees of safety. And I received a phone call this week from a group of people who asked me to listen to him. So I did, and he said, I would love for you to tap your call into it. I said, this is great information. We have serious activists on our calls, and I know people will make this happen. I got emails about this already. How do I do it? This is where I live, blah, blah, you know. So here's the number in case we're disconnected. You're going to call into 302-202-1114, and the code number is 307343. I'm going to repeat it again, and then I'm going to give you a couple of instructions as well. 302-202-1114, code 307343. There's probably a pound on there. I don't see it in this, but there probably is. You're going to hit 4, I think it's *4 to mute, according to this. And if you want to ask questions, it says 5 star. So I don't know if it's *5 or 5 star. Okay? So I'm going to attempt to dial this in. If it disconnects all of us, please just dial into that direct. It is starting right now. So hold tight, everyone. Looks like we made it in. Are you guys on this line? Brad, can you hear me?
I hear you.
Okay.
Yeah, I can hear you. I'm sorry, I was on mute. Yeah, I can hear you.
Okay, no worries. Okay, it looks like we're connected. So they're going to be getting started here, I would imagine, in a minute. It says our line is muted, so.
Line unmuted.
This is Randi Shannon. Do we have Wolf on the line?
Okay, good deal.
All right. And we have 42 Action tapped into the call tonight for Committees of Safety. Wolf, if you're there and you can hear me.
Yes, I can hear you.
Okay, very good. Thank you.
Well, this didn't work. I waited on it. It didn't work.
Hello?
Yes. We're just kind of waiting, Keith, for them to get started with their call.
Okay.
Committees of Safety. How are you doing?
I'm doing good.
Okay. By the way, the documents that everybody has called me about this week have not been sent to me yet. Okay, so don't think I'm ignoring you. I've actually spoke to the person that was to send them. I don't have them yet.
Okay, I got some good news this week in regards to one of my clients in foreclosure.
Go ahead. You can do it now, and if anybody has the phone on speaker, you'll have to take it off because it does give an echo. Go ahead, Keith. What's going on with your foreclosure?
Yes, the bank threw in the towel. and they canceled the sale, they canceled the foreclosure action, they canceled everything.
Wow. Good going.
What? Good
Line
job.
muted.
Oh, I don't know. Can you still hear? Can you talk, Keith?
Can you hear me?
Yeah, we got you. Good. Okay, go ahead.
Yeah, so that's what happened. They had the foreclosures. They had a sale date, and we fought that and got that postponed, and then they got another date, and we put some other paperwork in, and we filed in the district court for wrongful foreclosure, and we just been going back and forth. And then on Tuesday, we got a letter, a motion from the court, from the lender dropping the suit.
And they said?
Well, they said that they're dropping they're canceling the sale date, and they're canceling the action, and they're canceling everything. That was about it in details.
So you got your house. You own it free and clear? You going to get the title?
It's not my house. It's somebody that I was working with.
Oh, okay.
Yeah.
So what's the next step then?
Well, the next step now is to do the quiet title action.
Excellent.
Yeah, quiet title. Because now they throw in the towel. They don't have nothing to fight with now.
Outstanding. We'll tell whoever that was, congratulations.
Okay.
What was special about your paperwork, you think, that got the win?
I don't know. Well, the last thing that we did is we transferred the property into a third-party trust, and then when we did the transfer, we didn't record the deed. We did an affidavit of transfer, which was signed by the seller and the trustee. So I'm figuring, well, they couldn't sell it because the county didn't have possession to the property because they didn't have the title. That's what I'm figuring.
Okay. Brad, do you have any comments on that by chance? I know you're muted.
So we see once the final paperwork comes through, we'll see what they got.
Randy, I'm sorry, were you talking to me?
Yeah, did you hear what he said? I wanted to know if you had, I'm sorry, I was out here in the kitchen, but I had the phone on mute, and so I don't know, Keith, that still, any kind of win is a good win, so how soon do you anticipate doing the quiet title?
Well, I'm putting together the quiet title right now, so we should be able to file it next week sometime.
You don't think that they're just backing off and coming at it?
Line unmuted.
Action, do you?
No, I don't think so, because what I'm saying is they had already got the foreclosure in their favor, and they had two states.
Wow. Is the call starting?
Hello?
Yes.
Can anybody hear me? Yes?
Yeah,
oh, wonderful. Hi, guys. Nice to see you.
Good. Who's this?
Oh, my name's Maeve. I saw a video on YouTube, and so I decided I'd join.
Okay. Is Wolf on by chance? Are we getting ready to start?
Excuse me?
I was asking, is Wolf on? Were we getting ready to start?
On the chat? Oh, I hear it now.
Okay, so they're already started and we're not hearing it.
Yeah, they're pending.
You know, while you've got a moment there, Randy, I had come across pretty valuable information that I emailed to you. One was an FT.
That's going on. We're going to try something different. Evidently, the call he had to redo because they just standing at the door now.
Go ahead, Chris. It's okay. Go ahead.
Not a problem. The one was an FT.
How can it be better than a doornail if my loud mouth is here?
Well, we're tapped into somebody else's
I have
line,
the call and the internet on the same time. Is there one that I should switch to?
If you got it on the internet, you may want to stay there, because if you're hearing it and we're not hearing it, we should all just hang up and dial in direct.
Okay, yeah. Let's. Do you guys have the link for the committee site?
We have the phone number. What is the internet link? If you have it, you can give it out. That'd be great.
Yeah, I have it right now. I'll give it to you for I'll speak it to you. So one sec.
Okay.
It's let's see. It's okay. It's www.blogtalkradio.com/Sister Thunder Show. Okay. /215/101/30/Committees of Safety Talk Live.
Okay. So you guys, if you just want to go to Blog Talk Radio, if they just type in Committees of Safety,
their user is Sister Thunder Show.
Sister
and
Thunder
you'll
Show.
probably be able to find it. Yeah.
Okay.
You have it? Okay,
yep,
wonderful.
I think everybody's good. Thank you. Okay, you guys, Blog Talk Radio.
You're welcome.
Thank you.
Bye.
Chris,
yes, good. Yes, bye.
Bye-bye. Chris, I want to hear what you had to say. So,
well, does $16,000 per violation on FDCPA going back 5 years sound interesting to you?
Yeah, it does.
And if it was up till February the 9th of 2009, it's only $11,000, but beyond there, it's $16,000 per violation, and each bad action in the FDCPA is a separate violation.
Okay.
And
awesome.
At least it's up to that amount, and it's really a fairly well statutory fine, and the judges really don't have any authority to not award it if you prove your claim.
So also, you sent me something on it?
Yep.
Or no? Okay.
And
what's that titled?
Yeah, it's I think it's FDCPA from Pittman Law or something like that. Also, under 1692I, there is no non-judicial foreclosure allowed under the FDCPA. It must be a judicial process.
Okay, I'll look for that email, and anybody that didn't get it from Chris, please send me an email to support@42action.org. Support@42action.org. I'll forward it over to you. Just do it tonight because I'm here right now. And I wish we could get into that more. We'll save it for next week as well. But everybody hop over to that because I really do want everybody to hear about these committees of safety. Chris, you're awesome. You rock. Brad, thank you. And Keith for jumping in there as well. We'll cut our call here. If everyone can go over to that, this is super important, and I can't wait to hear everybody's feedback next week. We'll talk to you guys next week. Have a good night. Thank you, everyone.